A pleasant good day to everyone. We have done with the part 1 of the criminal law book 1. Now we are on the part 2, which talks about criminal liability as discussed under paragraph 4. The paragraph 4 is consists of two parts only, no? Once more, this is Dr. Ariel D. Manlusok, the director of the ADMRC. Yours truly, and thank you so much for subscribing and viewing my YouTube channel. And also an announcement, the ADMRC or Ariel D. Manlusak Review Center is now open for reservation for the final coaching. Okay, for the board exam for those who will be taking the board on November 2020. So we are opening the enrollment for the final coaching. So those who will be enrolling within the month of July and August, we will have a early promo, which is a 2 5 for those who will be availing our final coaching. For September and October enrollees, that will be 3,000 onwards. Okay, so that again, we have an early promo for those who want to have the reservation within the month of July and August. Okay, so this one, let's start now with the concept of criminal liability. Okay. So, paragraph 1 and 2 of Article 4 provides for two aspects. No? Generally, any person who commits a felony with all the elements present are criminally liable. Okay? Those who commit either dolo or deceit or culpa or fault. So, the paragraph 4 or the Article 4 rather of the revised penal code is actually discussing about people who are criminally liable despite the fact that their intentions or the intended crime was not fully been consummated or accomplished. Okay, so the first part is called the crimes committed by mistakes, and it goes like this: any person committing a felony, although the wrongful act done be different from what which he intended. So this is otherwise called as the crimes committed by mistakes. No, why? Because what actually happened is different from what is intended by the perpetrator. Now take note, this provision is only applicable to felony. No, we're not talking of offense, we are talking of felony. The second part is by any person performing an act which will either be a crimes against, no, which is only covered by crimes against persons or property, okay, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Or short, this is what we call in criminal law as impossible crime. Okay, now we will discuss them one at a time. So let's start with the paragraph 1, which is the crimes committed by mistakes. What are the elements? Okay, the elements for the paragraph 1 are the following. 1. That an intentional felony has been committed, means it is intentionally done by a perpetrator. And 2. That the felony be different from what he intended, meaning the result is different from what is intended by the perpetrator. Now, you might be asking, why is he criminally liable despite the fact that he did not accomplish what he wanted to happen? It's simply because of the principle of el que es causa de la causa es causa del mal causado. That is a Spanish principle which in the English translation, he who is the cause of the cause is the cause of the evil cause. Okay? Medyo nakakalito lang, no? Puro kuskus, no? But anyway, the significance of this is, no matter what will be the result, as long as the perpetrator starts the execution of a felony, there is a criminal intention. No matter what will be the result, he is accountable for the resultant effect of what he has done criminally. Okay? Now, when there can be no criminal liability, no intention or no intentional felony happens when the act or omission is not punishable by law. Definitely. If the act or omission is not punishable under the revised penal code, then it is not covered by this provision. or when the act is covered by justifying circumstances under the provision of Article 11. Yun po yung mga acts which is not considered as an intentional felony. Why? Because the perpetrators performed the act in good faith. Okay? There is good faith in the execution of an act. And as we discussed before in Mala in Se, okay, good faith is a defense for someone committing mala in se not to be criminally responsible for such an act. So what are the situation or scenario that are covered or that are included under the paragraph 1? The followings are included. Okay, so there are three circumstances. Take note, these are not crimes. Some students are getting confused about these three things. These are not crimes. These are only circumstances that even though the result is different from the intended crime of the perpetrator, there is criminal liability. The first is the so-called aberratio ictus. Okay? It is a Latin word. The English translation is mistake in the blow. Okay? Nagkamali ka ng binlo. Okay. Not other kind of blow, no? Baka may iba kayong iniisip na medyo green, pero it's in your mind, okay? So, mistake in the blow, thereby hitting a different and or another victim. So, what does it mean? It means so simple. You are trying to hit someone, but another person was the one that was hit by your blow. Okay? So to have an illustration, we have here X with intent to kill shot B with a pistol, but hitting C instead, causing the latter's death. Okay? This scenario is actually is an aggravated situations. Why? Because in this kind of scenario, there are two crimes that are actually committed. Why there are two crimes? Because X has an intention to kill B, but B was not been hit. So practically, that is an attempted homicide, right? But then, C, who is an innocent bystander or person, was hit by that shot and the one who suffered the consequences of the gunshot, and that causes death. That is considered as a consummated homicide. Why? Because the law provides that even though the intent is not apparent, but when there is death, there is an assumption that there is an intent to kill on the part of the perpetrator. Okay? So it's up to him to prove or disprove the absence of intent to kill. So in this case, okay, the consequence is X will be charged with consummated homicide as regards C and attempted homicide as regards B. So that is a crime of attempted homicide, okay, with consummated homicide. Now, why did I say with? Because the results are two, but the act is only one. This is actually a very good example of a compound crime which is under the classification of complex crime as discussed under Article 48 of the Book 1. Okay? We will have another provision for that or another video presentation regarding complex crime. No? I hope you wait for that. And that will clarify a lot of questions in your mind regarding complexity of crimes, okay, under the law. So here, there are two crimes actually, but there's only one charge practically. Why? Because there's only a single act, okay? And the consequence of that is under Article 48. What will be the consequence? The charge will be the person accused of a crime, once found guilty, will be charged or will be penalized based on the most serious offense. So kung alin po yung mas mabigat na naging bunga ng kanyang act, yun po ang pagbabasihan ng penalty and imposed in its maximum period. So in this case, the higher crime is consummated homicide, so the court will impose the penalty to the consummated homicide in its maximum period. That is the consequence of compound crime, which is one of the kind of complex crime, and that is brought by this one, the so-called aberratio ictus. Okay? I hope that is clear. Now, let's go now to the second and third situation. The second circumstance is called error in persone or mistake in the identity. Okay? Kung baga sa salitang kolokyal, wow mali, no? Bakit po mali? Kasi you shot or you kill someone but you kill the wrong person. Okay? You identify the person with another. Okay? So how are we going to illustrate it further? X with intent to shot B upon passing intent to kill shot B upon passing a dark alley, thinking that B was C. So what does it mean? From the very beginning, X thinking that he is trying to kill or he will be killing C, where in fact it was B that he killed. So nagkaroon ng mistaken identity, no? Napagkamalan ni X si B na siya ay si C. So in that situation, X is criminally liable. Again, why? Because from the very start, he has the criminal intention to commit a felony, although he did it to a wrong person. Okay? Now, the third circumstances of crimes of mistake, okay, is about the so-called praeter intentionem. Now, I will be discussing number 2 and number 3 together with regard to the consequences. No? Why? Because the result of these two will be governed by the provision of Article 49 of the Book 1 of the Revised Penal Code. So what is this praeter intentionem? Praeter intentionem is actually belongs to the mitigating circumstances under the provision of Article 13, Paragraph 3. Ano po yun? When the result is greater than the intention. Meaning, mas mabigat po, no? The outcomes becomes greater than what is intended by the perpetrator. Mas mabigat po yung naging resulta kesa sa hangarin ng perpetrator. And to illustrate, let's have one. X gave Mr. Y a fist blow in order to coerce the latter. So, sinapak ni X si Y para persahin, no? Pilitin, no? Si Y. Maaaring pilitin si Y na gawin ng isang bagay o wag gawin ng isang bagay. But Mr. Y fell on the ground wherein the head hits the pavement, a hard pavement, causing his death. So namatay po si Y because of that fist blow. So if you notice, the intention of X is only to coerce. No? It is an act of grave coercion under the Revised Penal Code. Crimes against personal security and liberty. But then again, the result is a death or homicide. So, what will be the consequence? Is there a criminal liability? The law said yes, because paragraph 1 of Article 4 is very clear. The person who commits an intentional felony, although the result is different from what he intends, incurs criminal liability. Now, the difference of error in persone and praeter intentionem somehow is the consequences. Okay? Ano po yun? The effect of the circumstance to the penalty. Okay? In error in persone, as provided by Article 49, the same with Article Paragraph 3, praeter intentionem, if the result is greater than the intention in praeter intentionem, the penalty will be taken from the intention. So, which is the lesser offense, dun po kukunin yung penalty, but imposed in its maximum period. Okay? Ganon din po ang principle sa error in persone. Okay? Whichever is the lower crime, that will be the basis of the penalty to be imposed. But in error in persone, in error in persone, there can be a different situation because this is the circumstances must be taken into consideration. That there can be an aggravating circumstances for the fact that the victim is an innocent one. No? And in that case, the crime might be given a greater penalty depending on the appreciation of the court of the circumstances of the crime. Just like in the case of People versus Oanes. No? We have an example of that later on. I will tell you that case of People versus Oanes. Again, reminder, this is not a crime. These are circumstances that will hold a person criminally liable, although the result is different from their intention. Let's go now to paragraph 2 of Article 4. Ano po yun? But before that, by the way, what is the principle behind the paragraph 1? Okay. One of the principle is the concept of evil intent or mens rea. So sabi nga natin, from the very beginning, the perpetrator should have the criminal intention. The second is the concept of el que es causa de la causa es causa del mal causado, or simply, who is the cause of the cause is the cause of the evil cause. Okay? Just like in our previous example, kung hindi sinapak ni X si Y, hindi siya magfe-fell sa ground. At kung hindi nag-fell siya sa ground, hindi tatama yung kanyang ulo sa pavement. Then kung hindi tumama yung ulo sa pavement, hindi sana siya namatay. So the law said, you are criminally liable because your act is the cause of the evil cause. Okay? And another is the principle of proximate cause. Now, this one thing is very important in criminal law, especially in crimes of killing. No? Why? Because in order for a person to be held liable for the result, it is important that we have to consider the proximity of the act and the result. And what do you mean by that? In order for one to be held responsible for the result of his act, the result should have been the natural, continuous sequence unbroken by any efficient intervening cause will produces the injury, without which the result will not have occurred. What does it mean? Let's make it short and simple. Your act must be the reason, okay, for the result. And the reason is done by natural and continuous sequence. No? Meaning, there is no efficient intervening cause. Walang ibang namagitan. No? Walang mabigat na namagitang bagay kung bakit nangyari yung krimen. Okay? Like for example, once you hit a person with a gun and you inflict a mortal wound, even if the person was able to run away, the person was able to go to the hospital, or he was brought to the hospital, but upon arrival he was declared dead on arrival, your act is still considered the natural and continuous, okay, reason why the person died, because of loss of blood. Okay, but definitely the loss of blood will not happen without that wound that you inflicted by hitting him with a gun. So that's the concept of proximate cause. Now, when can we consider that proximate cause shall be appreciated? Here. The death is presumed to be natural consequence of the physical injury when one, the victim at the time the physical injury were inflicted was in normal health. Meaning, it's very obvious that the injury that you inflict is the very and natural cause. No other reason for the person to be what? Dead. Okay? Second, the death may be expected from the physical injury. What does it mean? That the wound or injury must be sufficient enough to cause death to the person. Okay? Regardless of whether or not there was a delay in the medical attention or there was a delay in the delivery of the victim to the hospital or there is incapacity of the hospital to handle such situation, that is immaterial. What is material here is that the injury is sufficient enough to cause death to the person, although the death is not instant. Okay? And there must be a reasonable time between the infliction and the result of that injury. Now, when can we say that proximate cause will not be entertained by court? When there is an efficient intervening cause. Or some book called it sufficient intervening cause. There are two common example of sufficient or efficient intervening cause, and they are: one, when there is an active force between the felony committed and the resulting injury. Okay, now what is that considered as active force? No, sabi natin the active force, meaning there must be something that happens. Okay, and that happening is very strong. Like for example, the person, you inflict injury to the person. Okay, but the injury is not mortal. But due to the negligence or due to the pandemic, he was inflicted, or he was being what we call this, affected by the pandemic, or he was being contaminated with people with sickness, and that consummate, or rather that will increase or graven his condition, which later on causes his death, then there is an efficient intervening. There is an active force. Therefore, the one who inflict the injury cannot be held liable for the death of the person. Why? Because what causes the death of the person is a strong outside or external force that is beyond the injury. Okay? The second one, which is very common and simple, is when there is what we call intentional act of the victim. Like what? For example, carelessness of the victim or intentionally killing himself. Like for example, you stab a person with a knife or you fired a gun towards a person with intent to kill. He was wounded severely. He was able to escape, but he realized that he will no longer capable of surviving, no, and he is no longer capable of handling the pain, so it's very painful. So sabi niya, I cannot hold this longer, I should rather shorten my agony and my pain. So he killed himself, he slashed his arm or do other things. Then in that case, the person who inflict the injury is liable or not? Okay, it depends. If the injury that is inflicted is not sufficient enough, like for example, it's only slight physical, less serious, not sufficient to cause death, it's not fatal, committing suicide on the part of the victim is considered an efficient intervening cause. Okay. But if the injury is so severe, it's fatal, that there is no reason for her or him to survive, he commits a suicide just to shorten, okay, the pain, then I think with that consequence, the person is still held liable for the act committed or for the act that constitutes the injury, regardless of the fact that there was an intentional, okay, killing on the part of the victim by himself. Why? Because the wound or injury is by itself sufficient to cause the death. Okay? So again, we enter efficient intervening cause when the injury is or does not reach yet the fatal or the mortal stage. Because the moment mortal stage or fatal wound is reached, obviously there is a natural tendency for death to happen. Okay? Okay. Mistake of fact. Now, this is a question given in the board. There is one kind of mistake wherein the person is not criminally liable. So this is an exemption to paragraph 1. Because in paragraph 1, we have mistaken identity, a mistake in the blow, and praeter intentionem. This mistake is not belong to this group. Why? Because this is a mistake which is the person is not held criminally liable. Why? Because again, in this mistake of fact, normally there is a good faith on the part of the offender or the perpetrator here, no? What makes a mistake is because of the misapprehension of the facts or circumstances. No, nagkaroon siya ng maling interpretasyon sa mga pangyayari. That is mistake of fact. And he believes that he is acting in self-defense or he is acting in defense of a rightful thing, no? Meaning defending his rights. So he perpetrates an act, but he has to have precautions. Rather, he should exercise due diligence, no, so that culpa or fault will not enter the scenario here. So what are the elements? 1. The act done would have been lawful had the facts been the accused believed them to be. Meaning, kung tama yung nasa isip ng tao na nag-perpetrate ng act ay totoo o tama, legal o lawful yung kanyang ginagawa. Pangalawa, the intention of the accused in performing the act should be lawful, as I have said, and the mistake must be without fault. Meaning there is no negligence, there is no imprudence or carelessness on the part of the accused. Okay? To have an example here, common and simple example, the case of US versus Achong. So Achong is a caretaker of a certain facilities. So one very late night, he heard a noise coming from the door. And he is not expecting a visitor. So what Achong think is that there is someone trying to intrude the facilities. Okay. So he took a knife and approached the door. But he makes a precaution. He said, Sino yan? No, who is that? If you will not if you will enter, I will stab you with my knife or with a knife. But there was no response at all. He asked the person twice, but there is no reply. The only reply that Achong received is that the door was forcibly opened by the person on the other side. So when the person barges in, Achong stabbed him with a knife. But ultimately, it turns out that the person that is stabbed is a fellow, no, a friend of him. But he's not expecting him to visit. So the person died, but the U.S. Supreme Court held Achong exempted from the liability. Why? Because the court said there was a misapprehension of the facts. Achong believes that there is an intruder. Someone is trying to bargain and commit an unlawful act, and he is just acting in defense of his rights, in defense of his life, and the property that he is taking care of. Okay? What about the other one? The mistaken identity. So how are we going to differentiate it? This one. The case of People versus Oanis. Oanis is a police officer together with his fellow. So this is People versus Oanis et al. Et al means and others. They received an intelligence report that this wanted person with shoot to kill order is resting in a certain place. So they went to that place. Okay, they saw a sleeping man with his back facing the door. Immediately, Oanis gave a shot, and the other police officer also gave a shot. But it turns out they killed a wrong person. So in that situation, at Oanis, together with this man, are all criminally liable. And not only for homicide, they were charged and convicted for murder. Why? Because the victim, an innocent victim, died, no, without even a chance to protect or defend himself. No, there is a qualifying aggravating of treachery here and the use of armed man at the same time. If you look at it, okay. So in People versus Honest, that is a case of mistake in identity. In U.S. versus Achong, it is a mistake of facts. So Achong was exempted. Honest and his fellow police officer were held liable. Okay, the part 2. The part 2 or paragraph 2 is referring to impossible crime. Let's make it short and simple. When we say impossible crime, this is only applicable to those acts which would either be a crimes against person or a crimes against property. So, hindi po siya applicable sa crimes against chastity, crimes against honor, crimes against liberty. It's only limited to crimes against persons and property. So if the crime does not fall in Title 8 and Title 10, there is no such thing as impossible crime of those crimes. Okay? So, second element, that the act was done with evil intent. Again, the same with paragraph 1. There must be a criminal intent. And third, there is an impossibility. Imposible pong ma-accomplish yung krimen bunga ng anumang dahilan tulad ng legal impossibility, inherent impossibility, ineffectual means, or an inadequate means. So may apat pong dahilan bakit tinawag siyang impossible crime. But the law provides for penalty here. Okay? Let's have the reasons why there is such a called impossible crime. And these are the reasons. 1. Legal impossibility. A person steal a certain cell phone or a certain gadget from somebody else. But it turns out that he stolen a property that this belongs to him. No? Ninakaw mo yung wallet o cellphone ng ibang tao that it turns out yun yung wallet mo na nawawala. Yun yung cellphone mo na ninakaw. So you cannot be held liable for theft. Why? Because stealing your own property is not a theft. A theft is a stealing of others' property, no, without the latter's consent. So therefore, that is a crime of impossible crime of theft, and theft is a crime against property. Physical impossibility, no, you have a mortal enemy, so you wait until midnight because you know that this person usually hang out in his balcony. So you saw the man on his rocking chair, sleeping, you shot him with the gun, but it turns out that the person was already dead. So it cannot be a crime of murder alone. That is an impossible crime of murder. Why? Because you can no longer kill a dead man. Okay? Killing is applied to a living person, not to a dead person. So physically, you cannot kill a corpse. Okay. But again, there is a criminal liability. Employment of inadequate means, like putting a small amount or inadequate amount of poison. What does it mean? There are certain poison that needs to have a certain dosage, no, or certain amount that it is sufficient to cause death. So if the amount that you have administered did not cause death, okay, and as a matter of fact doesn't produce any effect at all to the person, that is a case of an what? Impossible crime. It can be an impossible crime of murder, no? Because the use of poison is a qualifying, aggravating circumstances. Another, employment of inefficient means. Okay? You you saw your mortal enemy, so you run away to the house of your parent. Then immediately you grab the gun to the drawer without even checking if it is loaded or not. You fired the gun to the person, said, "This is your last day." But the gun will not fire. Why? Because it is empty. There is no cartridge. So that is a case of what? Impossible crime. Of what? Of homicide. Why impossible? Because the gun will not fire. It is empty. Okay. Now, what if the act is possible to become a crime? Okay, like you ensure that the gun is loaded, but when you fire it, it causes a misfire or a hung fire, which causes that you did not or you failed to hit the person. That is no longer impossible crime. Why? Because that crime can already fall on attempted homicide. Okay? And the law provides, no, in jurisprudence, this is not in the codal, it is in the jurisprudence, no? We only charge impossible crime if the crime, okay, does not fall in any other crime, or it doesn't not fall even in either attempted or a frustrated. Because if the crime falls on attempted, frustrated, or you committed other crime, then you should be charged with the other crime, not with impossible crime. Okay, so I hope that is clear. So impossible crime are crimes only applicable to crimes against persons and property. Okay, but it can only be a charge if there are no other crimes committed, or the crimes does not fall in either attempted or a frustrated felony. Okay? And what will be the consequence? The penalty imposed by the law according to Article 59 will be arresto mayor. So you might be asking, bakit kailangang parusahan? What is being punished here is not actually the result, but the criminal intention of the person to perpetrate an act which is punishable or prohibited by the law. Okay? So that is the concept of impossible crime. I hope everything is clear. If you have questions, don't hesitate to comment, and I will be willing enough to answer as soon as I was able to view it, or I have the luxury of time to view it. Okay? So thank you so much. God bless, and keep safe. Okay, so before we end up, just a few reminders with regard to impossible crime. We cannot apply it to crimes which are not included in crimes against persons and property. No, so there is no impossible crime of kidnapping. There is no impossible crime of abduction and seduction. They are not applicable. Okay, but for example, the crime to be committed is an arson. Can there be impossible crime? Yes, because arson is crimes against property. Okay. What about rape? Oh, that's a good question. Rape before is not included in impossible crime, but now, since rape is part of crimes against person, there can be an impossible crime of rape. Okay, just like for example, you rape a woman that you thought is just sleeping, where it turns out the woman is already dead. So that is a case that can be a case of impossible crime of rape, no? Unless otherwise you are charged of trespass to dwelling, no, because you enter the place without the consent of the owner. So in that case, you can be charged of trespass to dwelling, because the law said if the person commits another crime, then you will be charged of another crime, not with impossible crime. But if there are no other crimes committed, then the crimes that you intended to commit did not materialize, and all the other elements are present there of impossible crime, then you will be charged with impossible crime. And there is a fixed penalty of arresto mayor, as provided by Article 59. So once more, thank you and God bless.